Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. In this video, we are going to discuss a case law on professional ethics. Professional ethics, that is standard of behavior, the rules which are prescribed by the Bar Council of India for regulation of the conduct of the advocates inside and outside the court. We all know that morals are to the society and ethics are to the profession. Here, Madras High Court held that advocate's fee, please remember, advocate's fee, which is illegal fee, cannot be a legal claim in the case of check bounce. This is a specific case of professional ethics. Previously also, before Justice Asha of Madras High Court, another such incident came, and Panuswamy lawyer case, and she declared it as a case of maintenance and champati. Now, Justice G. Ilangovan of Madras High Court, in the case of David Raj Vs V.Pavel. David Raj Vs V.Pavel, this Pavel is an advocate, held that the advocate fee, which is illegal, cannot become a legal claim. And he thrashed it. The check is for 10 lakhs. Finish. How this thing happened and why it happened, all these things, let us know step by step. Right. The advocate, the so-called Mr. Pavel, V.Pavel, actually he filed a private case of Section 138 of the Negotiable Instruments Act, stating that his client, Mr. David Raj, has given him a check for 10 lakhs, but when he produced the same in his account branch, and ultimately he was given the endorsement that funds insufficient. So therefore, since there is a breach of contractual liability, he filed a case under Section 138 of the NI Act against Mr. David Raj. And Mr. David Raj, he filed a petition before the Honorable High Court of Madras for quashment of the proceedings because there is no contractual liability between the so-called advocate, between him and Mr. Pavel. But why he has given a check of 10 lakhs? This is also an important point to know. Now, for that, the brief facts of the case are, David approached him. David Raj approached our advocate, Mr. Pavel, for legal assistance as he was having a debt of 1.5 crores, more than 1.3 crores at that particular point of time. This is in 2012, not now. Before 2012, he approached the advocate regarding the debt clearance and various criminal cases. Normally, he might have taken loans from so many people. He might have signed on so many checks and checks were bounced, and so many criminal cases would also have been registered against him. We don't know the fact, but criminal cases are pending against him. That's why he came to the advocate. Otherwise, what is the purpose of your going to the advocate? Okay. Then, as regards the fee, here you have to mean important dialogues. Right. So, Pavel demanded, please remember, 10 lakhs as the fee. Advocate demanded 10 lakhs as the fee. Fine. And this man said, because I am having about 1.3 crores due or so, I cannot give that much amount, Papa. But I have got some land. So I will give a sale deed for 10 cents of land. And saying that, he made him believe, the lawyer believed him, and at one point of time, he stayed in the office of the advocate in the year 2012, November 2012. Entire month he stayed in the office because of the life threat by the so-called persons who gave him the loans, threat to the life. Right. And 10 lakhs was allowed, but he did not pay any single pie. And when the lawyer demanded him to pay at least some amount. This man changed the advocate. Order 3, Rule 4 of the CPC. You may be knowing, the client can appoint advocate any point of time if he files wakalat. But Rule 39 of the professional ethics say that there should be no objection. Yes, this man, Pavel, he has given no objection, but he took 10 lakhs on check. That means David Raj executed a check for 10 lakhs. But it was bounced, and now the case. So now this David came to the High Court of Madras, stating that there is no contractual this thing. It is not a legally enforceable debt. So therefore, the check given by him, definitely the case can be quashed. Now the Honorable Justice, he has referred to the Legal Practitioners Rules 1973. Legal practice, even though there is no specific mention that the advocate has to take this much of amount for this case, just like CPC, because 138 NI Act, and he has appeared before him some other criminal case also. Even though you cannot fix up the fee structure, but 10 lakhs, demanding 10 lakhs, per se illegal. Per se illegal. Court held that it is per se illegal. And court, basing reliance on the famous case B. Sunita versus State of Telangana 2017. So held that it is not a contractual liability. There also in the case of Sunita, the advocate, that was an accident case, MV claim. So he has taken advance amount in the form of check. Now also our friend took the check, but Honorable Court said when the payment itself is not contractual. So that means the advocate's fee itself is illegal. Section 138 is not maintainable. It cannot become a legal claim. Right? So lawyer's fee, normally it will be based on the percentage of the decretal amount. And if you take more than that, definitely it amounts to misconduct, and you cannot file a case under section 138 of the NI Act. So this is the judgment. Please read it carefully. For the CPC students, please remember, next semester we are going to deal with the topic only. Then I will explain you in detail. But for the present, just go to the case law and enrich your legal knowledge. With this, I am stopping here. Thank you.